Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Now, you've described yourself as a judge as being an academic judge, and that you're trying to get the right answer. And I wondered if you could just elaborate on that a little bit. Are there different schools of thought on that point? I would think that all judges are trying to get to the right answer, but I wonder what you had in mind.
I think if I had to restate that, I would say that I'm a process judge. I once described myself to one of my colleagues as that our position is a guardian of due process. One of my colleagues, who's a federal judge, was confronted in a country store somewhere, and they sort of braced him, saying, "Well, are you one of them liberal judges?" And his response was that, well, if Congress passes what you consider to be a liberal law, I'll enforce it. And if they pass a conservative law, I'll enforce that. So I think we, as I mentioned earlier, we give up our First Amendment rights to some extent. And the pledge is that we will, stay within the lines and try to make sure that the process itself protects the law. Even if we may disagree with the result that we reach. And I've disagreed with a lot of the opinions, or a lot of the results that I have reached personally, but the law is the law.
What about your work in private judging? Do you see your role as being the same? Is it following a process, or is it trying to get a right result if those two things are different? Or is it a different kind of animal?
Well, one reason I enjoy it is that it's very much a different kind of animal, and it's more directly applicable to the problem. The legal process is opaque to most people, except for the lawyers. And the fact that I get to educate and advocate directly to the parties is, and it's required because they're the ones that are deciding what they're going to do with their case. They're all surprised to hear when I tell them that my entire career of almost 50 years, more than 95% of the cases that are filed in the court settle. And they're shocked by that. They assume that it all goes to trial. No, it doesn't. And one of the things that I'm enjoying about this private practice is that there is a growing realization, particularly post-COVID, that litigation is not like preparing for a battle. It's more like going on an expedition. It's more like taking a trip across the mountains and encountering different places where you have to do different things. And I'm seeing that lawyers are beginning to appreciate that more, so that you don't sit down and just think, well, I'll threaten the other guy that I'm going to go to trial and I'm going to win. And but that's really not what the process is going to achieve if that's your attitude. So I've always advocated against going away from the sort of chest beating, threatening, beat you in court kind of approach to being as collaborative as you can, that you've got two clients that aren't getting along and have a dispute and you need to help them resolve it. So I think that the new paradigm now is much more shifting in that direction. I can feel it. Partly because the courts are appreciating it. They're appreciating that managing the calendar rather than simply calling the case and trying it is a much better way to resolve the disputes. Basically recognizing that most suits should settle.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.